Probate in California is very complicated. The actual reason to have to go through probate is that when somebody passes away, if they own assets in their individual name that are above $184,250, those assets then have to go through probate court to be able to be distributed to their heirs or beneficiaries. The myth with probate court is that if you have a will, it actually avoids probate court, and this is not true. What a will is basically doing is saying, hey, here's my instructions on how I want my assets distributed. Court, please follow these instructions to make sure they're distributed according to my plan. So a will alone does not avoid probate court. If there is no will, there is what's called intestate succession. And this is basically California's estate plan for you when you don't have one. And it basically says how your assets are distributed according to your family tree. You know, if you're married, if you have children, parents, siblings, how those assets are distributed. The act of actually going through probate is a lot of paperwork. There's a lot of different filing deadlines. There's a lot of requirements that come into it. The process generally takes about 1 to 2 years to actually complete from start to finish, which means that if you are going through the probate process for somebody that was maybe the breadwinner in the family and now don't have access to their money, the family could be cut off from being able to access any of that money until the probate is done. The cost for probate is also very expensive, and it's set by statute by the state of California. So to give you an idea of how expensive it is, let's say that there is an estate worth $500,000. That $500,000 estate could be a home with just what the fair market value is. It's not the equity, it's how much it would actually sell for. So a $500,000 estate would cost $26,000 in statutory fees to go through probate court. In addition to that, there's also other costs: filing fees, bond fees, probate referee fees, publication fees. That's another $2,000 to $3,000. That's almost $30,000 for a $500,000 estate to go through probate court. When you're looking at starting a probate, there's a lot of things to take into consideration. The first is, do you actually have the standing, right? The right to be able to bring in a probate procedure or a probate proceeding. This comes into play as to what relationship you had with the person that passed away. You know, what's the reason for you bringing this probate? And this is where working with an experienced estate planning attorney is very important, because you could be filing a probate petition where somebody else could also be filing a competing probate petition. So it's important to make sure that you're working with an estate planning attorney. The first step, though, is filing that initial probate petition. And this will then allow you to get a court hearing, and essentially you would be getting letters testamentary. Those letters are what basically gives you the legal authority to now start gathering the assets in the probate estate. So being able to go to bank accounts, investment accounts, maybe sell real estate, all the things in gathering these assets. You now have an opportunity to start gathering any bills that are due to the estate, because publication needs to go out. Creditors need to be notified to be able to come forward. There's also some waiting periods in there. We have 120 days that we have this creditor period for anybody to come forward and contest what's going on with this probate petition. Once all of this has been done, the estate has been gathered, assets have been sold, and the money is now gathered to be distributed, there's another petition that's filed with the court where we will basically ask the court for permission to now distribute the estate. This generally takes about 1 to 2 years, right? It's a very long process going through all of this. At the end, once we do get that final order from the court, that's when the bills can get paid, the attorneys, the personal representative, all of the money from the estate can be distributed to the beneficiaries. And it's usually a few more months after that before we can get a final discharge from the court. So a few tips if you are going through probate court and you are the administrator or the executor. It's important to start gathering assets. And when I say gather assets, you might have no relationship with the person that passed away, or you were very close with them. And so it's your job as the fiduciary in this probate to now go through all of their paperwork, right? Look through everything when it comes to statements, looking at tax returns. Generally, when you are in January, February, it's a good time of year because that's when you get a lot of tax documents to know that there are assets that actually exist. It's also really important to look for any type of life insurance policies. A lot of times families, if proper planning hadn't been done, it's really just kind of an Easter egg hunt of being able to go through all of the records and find and gather these specific statements and assets to know what's involved in the estate. So that's the first thing, is really just start kind of getting an idea of what assets are available. The second thing is you need to make sure that you are caring for all of these assets, that you are taking control of them, you are securing them to keep them safe. Whether there's a property, making sure that the house is secure, you have the locks changed, neighbors watching the house, so that people aren't breaking in, people aren't going in to get things out of them. It's important to make sure that all of the assets, jewelry, electronics, all of that stuff is secure. Last thing I'll mention is changing your address or changing the address of the deceased to your address so that you now get the mail forwarded to you so you can see any bills or statements or things that are coming through. These are kind of the first steps to get started. A few problems that you would want to avoid if you are the executor or the administrator in going through probate court are, one, making sure that you secure the assets of the estate. So making sure that you're taking control, you're changing locks, you're making sure jewelry is safe somewhere, anything that's of value needs to be secure. The second thing is you want to make sure that you are working with an experienced estate planning attorney. The reason for this is that if you are not, and maybe you just have a family friend that maybe they're an attorney and they can help and you're trying to save some money, or maybe you're trying to do it on your own, there are a lot of procedures and petitions and paperwork and specific requirements that need to be met. And oftentimes we see people when they start this process on their own thinking, I can absolutely do this myself. We don't need to get professionals involved. It gets to the point that they do need to get professionals involved and they've already spent money and it's probably now going to cost more money to have to fix the problems that actually occurred as a result. The last thing that I will mention is not handling the bills of the estate properly. So a lot of times people think when somebody passes away, we don't actually have to pay the creditors. That is not true. You are required, if you are the fiduciary, right, the person that was assigned by the court to be responsible for this, you have a fiduciary responsibility to make sure that all creditors that you know of are getting notice of the probate, as well as filing a publication. This will allow creditors to come forward where you will need to actually pay those creditors from the assets of the estate. Once somebody actually understands what probate court is, the first question I get is, can it be avoided? Yes, probate court can absolutely be avoided. And the way to do this is by having a trust. A trust is a legal document where you are the grantor of the trust, meaning you're the one that's creating it. You are also the trustee of the trust, meaning you are in charge over all of the assets in your trust, and you are the beneficiary of your own trust. So while you are alive and you have this revocable living trust, and you are all three of these roles, you can do anything you want with the assets in your trust. You want to buy a house, you put it in your trust. You want to sell your house, you sign it as the trustee of your trust, and you sell your house. You're not confined to this trust. You get to do anything you want because it's your assets. And by having a properly funded trust, this is the way to avoid probate court. Because everything is in the name of your trust, there are no assets that would actually need to go through probate court. And this is how to avoid it and save a lot of money.